want me to, I will, but I'm happy to sit back and take it all in.
You won't be able to hear us this week.
That's part of the reason I'm back. Exactly.
Fair enough.
Last thing you need is let's see, next time such a but hadn't she just been appointed?
I didn't think you did the state.
Yes.
I would ask everybody in the courtroom, please make sure that you have all electronic making devices turned off. Okay. All rise. The Court of Appeals, Division 1, is now in session.
Good morning. Please be seated. This is the time and date set for oral argument in cause number CV 180529, Triple G Partnership et al. Versus Mohave County. These proceedings are being video and audio recorded and live streamed, so we ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if you desire. We have read the briefs. We have conferenced this case. We are familiar with the facts as well as the law. Take that into account when you are presenting. At this point, are you ready, counsel?
Yes,
Good morning and thank you. Burt Akin of Dickinson Wright on behalf of Triple G Partnership, Fred and Ted Grigg. There are several compelling reasons not to apply the county's common law dedication argument in this case. First, as Leo Sheep cautions, federal lands are unique. And applying this concept for the first time on federal lands would have a significant impact on property rights granted over 100 years ago. Second, a common law dedication requires the dedicator to identify the property at issue. RS 2477 did not identify any of the roads at issue. And you can look and contrast that with Pleak, which has been referenced in the county's briefings as what the standard should be. Pleak, there was a record of survey specifically identifying the road segment at issue. Third, none of the subsequent patents issued by the federal government referenced any of the roads at issue. So when the federal government transferred its rights to private ownership, it did not at that time assert that there was still a, or had ever been an easement on those roads. Again, that is in contrast to Pleak, in which the subsequent deeds did contain reference to the prior dedication.
Can I ask you a question that is not in the record and has nothing to do with the arguments? It's been Main Street for over 100 years. Why do your clients want to block it off?
Your Honor, fair question. Portions of the road have been deemed Main Street. Remember, we're talking about a network of roads. The roadways at issue are not one linear road. It's a network of roads. Portions of that were deemed to be Main Street in a dedication at one time for the Hackberry site. But other portions were not designated Main Street. And so, but getting back to your question of why close the road, and if I may, there is unfettered access to the town of Hackberry. Again, there are multiple access points. We're talking about a network of roads. One redundant access point that crosses my client's property was closed, and it was closed for safety reasons. What happened was the roadway washed out, and so there really was no safe passage, and so my clients put the barriers there, and it was at that time, for the first time, that the county asserted RS 2477 rights. So my clients have left open 4 of the 5 roads at issue.
So who repaired the road?
It remains closed today.
Historically, who had maintained and repaired the road?
Historically, this had been a county enclave with very limited to no maintenance. The record shows that the county did perform maintenance occasionally. But in the town itself, there's a sand and gravel operation that's owned, not operated by the Grigg family. They maintained the road from the town up to Route 66 in order for the larger trucks to use. But we're talking about roads that are lightly maintained, single tracks in some places.
But
roads of that
Council,
nature.
if you can clarify, this lawsuit is about more than just the washed out road?
Correct.
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 It's more the network of
It's-
roads you referred to.
Correct. It's the network of roads, Your Honor. And so the question is, the impetus for this was the one road that my client decided to close for safety reasons. Then the question is, but who has title overall? And so we said, well, let's get that question answered, and we proactively filed a title action to do so.
Turning back to your comments or references to RS 2477, so just so I understand, are you disputing then that could even make, it was not an offer? Because that seemed the county's position that created an offer. I mean, I know this is a little bit strange, but I'm trying to equate it to, contract 101 principles, an offer and an acceptance, but did it create an offer?
It created an offer for the construction of roads where on federal lands not otherwise reserved. And that offer could be accepted in any manner under state law. And that's the key here. We have never had in Arizona the concept of acquiring a road through use, acquiring a road through adverse possession. So if you look at other jurisdictions and how they approach this, they said, well, sure, that was an offer. The use was deemed to be the acceptance. What they were not doing, those other states, were looking at this as a common law dedication. No state's ever taken the position that RS 247 is a common law dedication. Instead, they were applying their state's existing adverse possession, prescriptive use concepts, and applying them to the RS 2477 context and saying, okay, you have an offer. Do you have the use that would be necessary for adverse possession under our state's laws? So when you're looking at some other states, that's how they've approached it. Arizona has said, yes, there was an offer, but you can't accept a road through use. So the counties, yes.
If that's true, doesn't that totally undermine 287041C?
It actually supports it, Your Honor.
How?
So 287041C was determined by Dawson to be a curative statute. It didn't transfer title. It said when a county or state expends money on a private road, it protects the county government agency from claims that it was acting in an ultra-virus manner, spending money on private roads.
And so that undercuts the city's de facto taking, but doesn't
Yes.
that undercut your no common law dedication argument? Because when we look at Miller v. Dawson, it says that title does not vest in the agency or the state title remains in the hands of the landowner. So isn't that just common law dedication?
Oh, I don't think it is, and I'm
Well,
glad.
to follow up before, I don't know if this fits, but couldn't there still be an easement under that statute and still conform to the intent of that statute? Not title, but
To the curative statute?
yes.
I don't believe so. Remember, Dawson was saying, because if it's an easement or it's fee title, it is part of the property rights that were once held by the owner. And and I don't read Dawson to say, well, the issue was that statute took too many property rights. The issue is, can it take property rights at all? Answer, no, it's a curative statute. And so I don't believe the distinction is between easement versus fee title. It is, can use and maintenance be deemed to transfer something that was private into public under
Any
title?
one, you're saying any one of the bundle of rights, you're saying that's your position, it could not, through RS 2477, you can't transfer any, whether it's full fee simple title or an easement or otherwise.
Well, correct, Your Honor. And think about it this way. If the action of maintaining the roadway was sufficient to transfer an easement, again, there's no purpose for the curative statute. Because once they have an easement, and this is in the county's position, they have an easement there, they can continue to maintain it. And so I look at that curative statute as black and white. You either have a property right or you don't. And the answer is you don't, but you're protected because of the curative statute from any claims that you did not have any interest in the property. So back to, are there any other questions on that? On the common law dedication, because again, I want to reemphasize, no state anywhere has found that concept. I mentioned the fact that typically in a common law dedication, you see a reference to a specific road. Yes, you have an offer for the construction of roads in the future. I'm not aware of common law dedication being an offer for a road that does not exist but may exist in the future. Additionally, PLEAK, I believe this was an important component of PLEAK, was that not only did you have the offer to dedicate and subsequent use, but that the owner referenced those that easement in subsequent deeds when he or she transferred the property. And if you look closely at PLEAK, that is the discussion in there, that there's two parts. It's the recordation of the easement and then subsequent deeds reference it. And why is that important? To put people on notice.
Okay, to put people on notice, your clients, Triple G, basically your clients are the main residents of Hackberry.
Yes, Your Honor.
And if we look historically at the use of this road, it's been in use since the 1800s. So, would you agree with that?
It's important, Your Honor, to make sure that we are talking about 1800s, and 1883 is an important time period because 2 of the 5 parcels left the public, open, unreserved lands in 1883, the railroad parcels. Once the railroad submitted the completion map, those lands that the railroad had were no longer subject to entry. So you say 1800s, it's important to say pre-1883 or not. I don't believe there's anything in this record that shows general public use of these prior to 1883. Certainly the railroad was. The railroad was building a railroad. I mean, so the railroad was the one that probably built the road. But as far as general use, on this record, I don't believe it has anything that shows that the public used the railroad's roads before 1883.
Okay.
But I'm not sure that answered your question.
Not exactly. 1883 you think is pivotal, but the public was using the roads up to the point your client blocked the road. Would you agree?
Yes.
And if that wasn't the case, nobody would have had a problem with your client blocking the roadway.
I don't know that anybody other than the county asserted a concern. I mean, the record is, I believe there's information in the record that we submitted in support of closing this road. I'd be happy to follow up if necessary, but I'm pretty sure that's in the record. There are a number of nearby residents that signed a petition saying they supported closing the road. It's been many years, so that's my understanding. I do want to reserve some time, so if you have any other questions, the only other thing I wanted to mention now is I did note that in our opening brief, I referenced the wrong fee recovery statute, and so I just wanted to point that out and say, mea culpa, we do request fees pursuant to 12-1103 under the quiet title action that we filed. But thank you.
Thank you.
May it please the court, Laura Curry of Jennings Strauss on behalf of Mohave County. And the issue before the court today is whether this public road known as Main Street, that's been maintained by the county for over 100 years as a thoroughfare for public travel, should remain open as a public road. And I'd like to start by addressing some of the issues in Triple G's appeal first, and then address the issues in the county's cross appeal. So Triple G's appeal boils down to an assertion that the federal government either cannot dedicate property for a public use, or that such a dedication can't be accepted through common law, through the elements of common law dedication.
Are you aware of any other state that has applied common law dedication in this context?
No, I'm not, Your Honor. And the reason for that is in any other state, Western state, that was where roads under RS 2477 were created, mere use is enough to accept the offer. So they never needed to do a common law dedication analysis, because in all the jurisprudence you'll read, just by the public using the road, that's enough to pass fee title. So the analysis that we're doing under Arizona law, in order to pass fee title, you have to comply with the elements of the statute to establish a road. But in order to establish a public road through common law dedication, it just requires an offer and acceptance by the public or the government entity.
So in those other states, essentially, they recognize that the government can obtain property by prescription. Or adverse possession.
I don't know that they recognize the
Well,
government
but
can.
implicitly?
Because some of these roads.
Isn't it as implicit then?
Well, a number of these roads that were created in other states, they didn't necessarily involve any government action at all. They'd be wagon trails or footpaths over federal property used, well, in our example, to establish a mining claim. This mine predated the railroad. The road to reach Hackberry predated any construction of the railroad. It was to access the Hackberry mine. So these are the kind of roads that were created. They're not, great thoroughfares. They're by nature horse paths, wagon trails, footpaths. And so in other states, it's not that the law is the government can create roads by prescription. It's that RS 2477 offers can be accepted by the public through use.
Okay.
And I mean, it fundamentally, the idea that the government somehow has less right to appropriate or dispossess itself of property than a private property owner, fundamentally doesn't make sense, which is kind of the basis of why Triple G is arguing that Pleak shouldn't apply to this situation. They're saying, well, Pleak was a private property owner deciding how to use his private property. And well, the idea that the federal government couldn't make the same decision, there's no support for that in the law.
Can you address his argument that Pleak is a two-step inquiry requiring use plus documentation of some kind?
I believe that Pleak was a case where it involved a road that actually did show up on a plat. And I think Pleak actually went into some analysis of what do we need to look at for use, and kind of put it aside, saying we don't even need to get into this quantum of how much use is enough, because we have a plat recorded by the property owner, and that's certainly consistent. So you can imagine there could be common law dedication cases where there wasn't an explicit plat, and then you might be looking more at the quantum of use. But I don't believe that plat stood for the position that you needed a certain amount of both, and just because there was a plat in that case.
Council, so council tells us that what we're dealing with here is with a network of roads, and that his clients merely blocked off one, leaving these other routes open. Does that or should that affect the analysis here?
It shouldn't, Your Honor. I direct you to the judgment in this case that describes the road that was the subject of this case and that the county was trying to open. And the fact that there are other circuitous routes to arrive at the same location doesn't mean that this road should be closed or there's any legal justification for closing it. To the extent they're talking about a network, I think they're referring to offshoots of Main Street that allow access to other parcels in the area. But I believe that the judgment in this case dealt with Main Street / Old Trails Highway.
And there's a legal description in the complaint.
Attached to the judgment, yes. Some of the other issues that Triple G raised focus on the fact that they say that none of the patents reference the road that were. Actually, let me backtrack. They've focused on this idea that in 1883 is when the first of these parcels left the federal government's ownership. And we would disagree. That railroad property, there are patents in the record showing it being patented in 1923. So just, I wanted to clarify that the county does not agree with that interpretation. But also, we'd say that even assuming that the property left the government's ownership in 1883, you can see clearly on the railroad completion map that this road is in existence as the only access to the township of Hackberry. So it was accepted, the offer was accepted prior to the transfer of property from the public domain, even under Triple G's facts.
Can you tell me where in the record the railroad completion map is?
Yes, Your Honor. That's Record on Appeal 42, and it's Exhibit 2.
Thank you.
You're welcome. And also note the railroads depicted on the two general land office plat maps that were approved and accepted by the United States Land Office. That's also Record on Appeal 42. It's at electronic page 19 and 21. And I only bring that up because to the extent that Triple G has been arguing, well, these don't show up on any kind of plat maps or any kind of government maps, all these patents that were issued back in the early 1900s make reference to these plat maps that show the land that's being distributed. So the idea that there's no reference to these roads isn't factually accurate. But beyond that, there doesn't need to be a reference to an explicit road drawn on any kind of plat in order for an RS 2477 road to be created. And part of the reason for that is the nature of these roads that we've that I've discussed earlier. These are wagon trails, footpaths over various portions of the western states. So, I mean, the federal government has no practical way of keeping track of every dirt road and putting on every patent that's issued. So in all the other kind of, not all, but in many of the other RS 2477 cases, these aren't roads that show up on plats either because that's the nature of the roads. I'd also like to direct the court to, let's see, Record on Appeal 42 at Exhibit 1 are the maintenance records from the county for Main Street and Old Trails Road. And they show that the county was out there, I mean, county employees were out working on the roadway property nearly every month from July 2003 until September 2015. They were blading, grading, patching holes, performing maintenance on the cattle guards, repairing storm damage, exactly the type that Triple G is arguing was the reason they closed the roads. They pushed snow off the road in winter months. They repaired fencing along the road. It was not the kind of maintenance that you'd see on like Central Avenue in downtown Phoenix, but they were out there regularly. So this idea that Triple G might claim they were unaware that the county was performing this maintenance would be an unbelievable assertion. Unless you have any more questions on their appeal, I'd like to move on to some of the issues in the cross appeal. So for the county's cross appeal that it's acquired title to the property through the power of eminent domain, Triple G's basic argument in opposition, well, one of them is that the county hasn't done enough to affect a taking.
Can I stop you or
Absolutely.
digress for a second? Why, can you explain, and perhaps it's not in the record, but if you can opine a little bit, why does the county prefer this to be fee simple versus easement? Why does it matter?
Well, I'd offer two reasons. One, because the county believes it's acquired fee title, so it wants to protect any and all of its property rights. And two, there are public
I mean,
policy.
can I follow up on that?
Sure, sure.
To just push back on that a little bit. Doesn't the landowner pay the tax? I mean, I'm sure we're not talking about, we're probably talking about pennies or dimes in the overall scheme of things, but doesn't the landowner pay the tax on those roads?
Yes,
The taxes,
which
okay.
actually leads into policy reason number
Okay.
2, why when the county establishes roads, they prefer to do so with fee title, because the reality is that the phantom estate under a roadway that's got a public right-of-way easement is virtually worthless. So it's in Triple G's interest that to find that fee title is passed, because then they won't pay those pennies of taxes for this property.
And perhaps liability as well. Okay.
Absolutely, absolutely. And there's a case, I don't think it's cited in the record because we didn't really get into the policy reasons, but Town of Paradise Valley v. Laughlin is a case where the court actually discusses this policy reason and how there's virtually no value to the estate under a public right-of-way.
If the county wants fee title to it, why didn't the county take steps before Triple G obtained this property to acquire title to it, to quiet title in the county? Why did the county do nothing? Because it's included in the transfer paperwork. I mean, the deeds, etc., the
The
patents.
patents.
Why didn't you take steps as the county to ensure that you had fee simple title to it before it started getting transferred through private hands?
Well, quite frankly, Your Honor, this is a case where the county thought they had done what they needed to do to establish the roads. We don't contend that they met the letter of the statute in every instance, but they held a meeting, they marked these roads as county roads, they accepted it, they recorded it with the county recorder, and this is back in 1916. So the reason the county didn't do anything is because they thought they were operating the road under ownership of the road. And this is, especially in the context of roads, when you have a de facto taking, this is often how it comes up. There's undocumented right-of-way, and quite frankly, this isn't the only undocumented right-of-way in the state of Arizona. There are going to be roads that the government took and opened and maintained and have been using and spending public money on, where fee title may not have passed through the usual steps, or they didn't go through the statutory eminent domain process, but that doesn't mean it hasn't been a government taking.
When we talk about easement and the bundle of rights that come with being the property's owner, how is the use of this roadway or roadway system inconsistent with an easement?
Inconsistent with an easement?
Common law dedication kind of easement. I'm equating the two.
I mean, I would guess that this fact scenario is different because they show up as county roads. They're part of the county's record in terms of county roads, and the county's maintained, used, and invited the public to use for 100 years.
What I'm asking you is this: if we affirm the trial court and all the county gets is a common law dedication, which is akin to an easement,
Mm-hmm.
what's wrong with that?
I mean, the road would stay open as a public road either way. So if this court chose to simply affirm the trial court's ruling and not find that the government had effected a taking, that would be okay. We would argue that legally the government does have title, but if that was the decision, the road would still be a road. So the bottom line practical result would be the same, But for the reasons we discussed, the policy reasons, those would be different. So there'd be practical differences in that sense.
Well, based on your earlier comment that triple G virtually has there's no real value underneath the road, couldn't the county just proceed with condemning? Because there is no value. I mean, what appraiser are you going to have? What appraiser is going to get on the stand and say, oh, there's great value to the difference between an easement and fee title? I mean, as a practical matter, wouldn't that be an option?
I mean, that would absolutely be an option if this court rules that the county doesn't have fee title. But the reason the county hasn't done that is because they believe they have fee title already.
And I'll be honest, I think that the notion that the government can acquire de facto property through de facto taking I'm highly skeptical of that notion, just because I don't think that's what our Constitution depends on. I don't think that you can make an end run around paying fair and just compensation, even if I understand the arguments you're making, but it just troubles me. I'll just put that out.
I guess I can understand why it might trouble you, but that's definitely black letter Arizona law and how
But
it's
it's
been
usually
interpreted.
9 times out of 10, if not more, it's raised by the property owner saying, hey, this is a de facto taking. You're taking my property because of the regulation or the threatened condemnation or what you're doing. You're using it in a way that you're pouring flood water onto my property. That's a de facto taking. You owe me money.
Yeah.
But I'm not aware of any case that says, oh, that means the government gets a deed in fee title to that property.
Your Honor,
That's essentially what you're asking.
if there's been a de facto taking, then the only remedy for the property owner is to bring an inverse condemnation claim. That's why those are the cases you see, because those property owners are asserting their rights. They're saying there's been an unconstitutional taking because I haven't been paid just compensation. And if there's been an inverse condemnation, the courts have said, yes, there's been an unconstitutional taking, but that doesn't mean there hasn't been a taking. Your remedy is the payment of just compensation. And like any claim with a statute of limitations, it's possible to lose that claim by sitting on your rights. And so it's not the government, the fact that there's no claim to just compensation in this case, this wasn't brought as an inverse condemnation case. So we can't speculate as to how those arguments would have gone down. But the government, the county in this case, would preserve any of its statute of limitations defenses. And I do want to point out while we're talking about de facto takings, because it's, again, black letter law that any substantial interference with any bundle of property rights in the stick does constitute a taking by the government that's compensable. And in this case, not only is there ample evidence in the record to show the county has effected a taking of the roadway property, but in their own complaint, Triple G alleges that because of the county's actions, Triple G, quote, has been deprived of the beneficial use of the property. And that's the black letter definition of a taking. So even if we're not getting into a quantum of was this use enough to affect a taking, Triple G has admitted this interference with their property rights.
And I would like you to address 287041C and the case law interpreting that in relation to this argument.
Frankly, Your Honor, it's my reading of Dawson that the curative statute has no impact on the government's constitutional power of eminent domain. The court in Dawson, in interpreting the curative statute, was mainly concerned with the property owner having the opportunity to bring a claim for just compensation. They were worried that, there's no statute of limitations in the curative statute, so they can't have meant to pass title. And the state in Dawson was arguing that the curative statute had passed title from the property, from the owner to the state, either by virtue of the curative statute or through prescription. And so because of that, the state didn't have to pay the property owner at all. And the property owner brought this inverse condemnation claim saying, no, there's been a taking, I'm entitled to just compensation. And the court in Dawson determined that the curative statute didn't absolve the state of its constitutional duty to pay just compensation, so it was remanded for the property owner to continue with its inverse condemnation claim against the state. So the upshot of Dawson is not that the state can't accomplish a de facto taking of property for a roadway. It's that if it's not prescription, then it's a taking that triggers just compensation. And again, in Dawson, there was no even inkling of talk that they were going to close the highway. The remedy was a claim for payment for the property that was taken. And to the extent that there's any kind of confusion about these differences between prescription and adverse possession and takings, it's pretty well covered in the briefs, but I kind of want to point out that, with prescription, we're talking about non-exclusive use for the statutory period, an easement passes with no compensation to the property owner. In adverse possession, it's exclusive use for the statutory period, title passes to the user, and there's no compensation to the property owner. And with the taking, we're talking about the government using property for a public purpose, and there's no statutory period. The taking occurs the moment that the government substantially interferes with any of the property rights, and the government is required to pay the property owner just compensation for the taking. So that's a big difference between the cases that Triple G is kind of trying to conflate. Prescription doesn't trigger the right to compensation. A de facto taking does. And I don't know if there are any other questions in this last 10 seconds, but we maintain that the trial court correctly determined the roadway is a public right-of-way established via common law dedication, but erred in determining that the county didn't hold fee title, so we'd ask the court to reverse the trial court's decision regarding the takings claim and find that fee title has passed to the county.
Thank you, Ms. Kerr.
Thank you.
Mr. Atkin.
Thank you. I just have a couple points I'd want to make. You asked about Pleak and the reference to the subsequent conveyances. In Pleak, paragraph 3, paragraph 2 talks about the survey, which was the initial common law dedication. Paragraph 3 says, the developer then sold the lots created by the survey. Each conveyance document expressly referenced the survey. Again, that's a direct distinction from our case where none of the federal patents expressly referenced the roads.
Can you address, Exhibit 42, the land office plat maps and the railroad completion map referencing, there is some documentation. Why is that not sufficient?
Some documentation, thank you, Your Honor, is not expressed, right? Are they saying, I don't think you will find in those deeds that you are taking title subject to every road and trail that is showing up on this? Because you have to remember, we're talking about different maps with different purposes. A general land map is going to show landscape features, roads, trails, things of that nature. A patent's going to show, what are you acquiring? And those patents show the land, and they also show easements. And each one, I believe, showed a number of easements. None of them showed these roadway segment easements. And so I guess that's how I would distinguish it. In paragraph 23, again, there's a reference to, says, there's no dispute in this case that the lots in Entrada were sold after recordation of the survey, and that the conveyance document specifically referenced to the survey. And so, you take the court at its word that it included that language for a reason. That's absent here. You're being asked to draft a common law dedication that's been used in private lands to federal lands. As I mentioned earlier, we think that should be done very carefully and thoughtfully, and not at all here under the admonition of Leo Sheep, as well as the prior Arizona case, Supreme Court decisions. So, the county's argument is a creative one, but at the end of the day, Arizona has had a system that has worked. If you want to accept an RS-2477 dedication, you had to follow the statutory procedures. And that served the state well for over 100 years, and there's no reason to change course today. I'd be happy to answer any questions.
Thank you,
Thank you.
counsel. And with that, we will take this matter under advisement. We will issue a written ruling in due course, and we will take a short recess.